All right, we're still talking about the police in some extent, but we're also beginning our transition over to discussing the court system. So, of course, some of the foundation here is the Constitution of the United States. So we're going to look at some of the rules of law enforcement, and this will give us kind of a nice bridge the next couple weeks or so when we move over to the court side. All right, the Fourth Amendment of the Constitution of the United States. The application of the police really has to do with arrest and search. So if we look at the Fourth Amendment of the United States requires that an individual be protected, whether he's an American citizen or not, against unreasonable search and seizure. It also requires that if you're going to issue either an arrest warrant or a search warrant, that you have probable cause. And we're going to need to define both those terms. Okay, so let's go to reasonableness. First of all, reasonableness is very much a situational question. The term is different in every case. What's reasonable if someone's holding the gun at the head of a 5-year-old child is different than if someone is in an office potentially committing embezzlement. So the term reasonableness is also linked to probable cause. Now, probable cause is not the easiest thing in the world for a lot of people to understand and define, but we're gonna work on it here. Okay, so probable cause is more than a mere suspicion. A police officer might look at a situation and say, I'm suspicious that this guy committed the crime, or I'm suspicious that this crime in fact occurred. But a mere suspicion is not probable cause. It doesn't give the police officer rights to arrest. It may give him, the suspicion, a basis to continue his investigation. And when he does that, we can look at these 4 things. What does he personally observe? Given his training, given his observational skills, given his expertise, what can a police officer, when he looks at a situation, determine? And sometimes he can determine, okay, I understand. So let's take something like drug use. The average citizen probably is not exposed at all to most of the severe types of drug use and abuse in the United States. It's clearly a crisis, clearly a problem. But the closest most of us get to drug abuse is TV. And that's not really very accurate. One of the things it might miss, for example, is smell. Police officer might, through his expertise, know very much what a meth lab smells like. Well, that's pretty dangerous. Or it might be marijuana. He might be able to distinguish and say, okay, that smell is marijuana. Now, the second source of probable cause can be information. This is information received from others. This can be information received from other police officers, from their own personal observation, from witnesses, from the coroner, from scientists, whoever. Information can be very valuable to establish probable cause. Evidence. Evidence is nice because it is tangible, it is physical, it is touchable. So evidence could be a videotape. Evidence could be a gun recovered at the scene of the crime. Evidence could be blood samples, semen samples, hair samples. All of those could give the police enough information to go forward and make an arrest, or go get a warrant, because the warrant for search also has to be based on probable cause. Now, what's generally not enough is mere association. The first 3 are stronger than the last one. Particularly the third one is the strongest, I would argue, overall. Physical evidence can be very hard to dispute. But association, known criminal in a place where criminal activity is openly taking place. Simply because you're in a location where a crime is occurring doesn't mean you're a criminal, for example. Let's suppose you had a social worker who was doing an investigation about a battered child. He might be in a situation, he might be in a bad neighborhood, he might be in a good neighborhood, whatever. Doesn't mean that he's the person committing the crime. You might have a priest or a minister or a rabbi or an imam who is caring for people in difficult situations, sometimes even criminal situations. They might be trying to get someone off the street, someone who's an addict. And if you came across them, simply because they're there where there are illegal drugs, doesn't mean they either possess them or use them. Now, way back at the early part of this century, the police pretty much were free, even if they didn't have probable cause, that if they gathered up evidence, they could use that evidence against people. Gradually, the Supreme Court of the United States established, however, the exclusionary rule. And what they said was, if the police obtain evidence illegally, and that's usually going to be either from an illegal arrest or an illegal search, that evidence cannot be used against the party whose constitutional rights were violated. All right, one of the questions I get from students all the time is, why? This doesn't make any sense. And it didn't make sense to some legal scholars and still doesn't to some. Most famously, Judge Cardozo, a very famous judge out of New York, said, why? Because the constable has blundered, the criminal must go free? Just because a police officer made a mistake, we're going to let a guilty person go free? And that's certainly one way of looking at it, but look at it this way. If you don't prevent the admission of evidence that is seized without probable cause, why would the police bother to have probable cause? If you say, well, no matter how the police get the information, we're going to use it, then you are telling the police it's okay to use any method to get it. Conversely, if you tell them there's an exclusionary rule, if you seize evidence illegally, we won't admit it, you're going to force the police to operate within the boundaries of the Constitution. Now, we've even gone a little bit further, and this was because the initial decisions were in the early 1900s and all the way up through the 1960s, we kind of expanded the exclusionary rule. We say, and this is called the fruit of the poisonous tree, that if you find illegal evidence, and it even leads to more evidence, that evidence is also inadmissible, but only inadmissible against the party whose constitutional laws or rights are violated. So if you search my house without a warrant, and you find evidence that I killed Fred, and you find evidence that Barney helped me dispose of the body, well, under the exclusionary rule and the fruit of the poisonous tree, it's inadmissible against me, but it's admissible against Barney. Any diary or evidence you find, it's all admissible because his constitutional rights weren't violated, just mine. Some of the exceptions to the exclusionary rule, because it's been criticized, is inevitable discovery. If the police would have found the evidence no matter what, we're going to admit that evidence in good faith is another exception. Evidence that the police really thought they had probable cause, that it was well established, they thought they had a valid warrant, they thought they had a valid either arrest or a search warrant, and there was a minor technical error, or there was just an error the officer was unaware of, we're going to admit it. I'll give you an example that occurred in Raleigh. Not directly related, but it's a Raleigh case, so I think it's... The police stopped an individual with one taillight out in Raleigh. Now, the police officer didn't know, and to be honest about it, I didn't know this until I read the case, that the statute regarding improper equipment, where a police officer can stop you because there's something in your car that's wrong with it, says so long really as there's one functioning taillight, you're okay. It's not a offense. Well, the police officer didn't know that. He stopped a car with one taillight that was out. There was a search of the car. Illegal drugs were found. It was appealed to the Supreme Court of the United States. The Supreme Court of the United States said, all right, well, because the police officer had a good faith belief that the search was legal, the search was going to be upheld. And you know, if the police officer had just stopped the car because he didn't like who was driving it, you know, he has something against, you know, pick a racial or an ethnic minority, he has something against people from Fiji, and he pulled over anybody that looked like they were from Fiji, well, that would be invalid. All right. You have to understand that privacy is very important in understanding laws about search and seizure. Anytime the government searches, this is an intrusion on a citizen's rights. And those rights are strongest when a citizen has an expectation of privacy. And that expectation protects people, not places. So what we ask is we ask a two-pronged question. One, should you expect privacy in that situation? And two, is that reasonable? So let's take an example where it isn't. You have someone that's arrested and in prison. Should an individual expect privacy in his jail cell? And the answer is no. All right, let's take the opposite extreme. Should you expect privacy in your own home? And the answer there is yes. Particularly in states, North Carolina, there is a high degree of respect and emphasis placed upon the rights of the homeowner. If you are in your house, the police should have a pretty good reason to come in. They shouldn't just be able to come in like they could to a jail cell. The role of privacy in searches. One of the ways we determine whether there's legitimate privacy interest is, what have you done to ensure that what's going on is private? Did you close the door? Okay, well that's an indication. If whatever you were doing out in the open. You know, there's a world of difference between you doing something in your front yard people can see driving by. Suppose you're growing marijuana in your front yard. Okay, that's different than if you're growing marijuana inside your house. Of course, we have kind of a tension between how technology has advanced and our desire for privacy. Recently, evidence gathered by GPS devices have been ruled inadmissible unless the police had a warrant for it. So we're going to see this in the future. All your phones that you use have GPS devices in them. Question's going to be, do I need a warrant to get to it? Do I need a warrant to see it? How much do I need to see? When can I see? How specific can I see? A search warrant is a written order by the court that says the police can search a particular area for a particular thing. So it identifies, first of all, it shows that probable cause exists. So it says, this is why I believe I'm going to find something. So let's suppose the police are investigating a homicide. And they think John Doe has killed somebody. And the homicide was committed with a rifle. Then the police officers might go and get a warrant saying, we want to search John Doe's house for the rifle. So they're going to talk about what they're going to search. They're going to search the house, whose house, John Doe's, and what they're looking for, the rifle. Okay. They're going to have to say why they believe the rifle is going to be there. They're going to have to say, okay, John Doe was seen with a rifle numerous times. We have pictures of him on Facebook with the rifle. That rifle matches the kind and type that was used in the homicide. Therefore, you would go to a neutral judicial magistrate, a judge, and you would say, I would like a warrant to go to John Doe's house or to his office or to his place of work, wherever that is, and I would like to search for that rifle. It is not a right to search for everything. It's got to describe where you're going to search. And you have to write a statement of the facts. And while you're searching, you are limited in what you're looking for. So there was a case, and again, if you take constitutional law, we'll go over these in much more detail, where the police were looking for a felon. They were looking for a physical individual. So let's suppose the guy's 6 foot tall. They go to search someone's house, and there's a small box. The box is, let's say, a foot by a foot. And the police officers open the box, and in the box they find evidence of crime or criminality. In this case, the case I'm thinking of, they found illegal pornography. And they arrested the homeowner, that'd be a woman, for possession of this pornography. And she said, well, this is not a reasonable search. Yes, you had a warrant to search, but you had a warrant to search for an individual. Individuals aren't going to be located in 1-foot boxes. Let's chop them up or something. So that search was unreasonable, and the courts said, you're right. The police did not have a right to search. Therefore, under the exclusionary rule, that pornography is inadmissible against that homeowner. All right, so what can be seized using a search warrant? Well, first of all, items that result from a crime. You rob a bank, we can seize the money we find. Items that are inherently illegal for anyone to possess. We search your house, we find marijuana. Well, we're assuming we're in a state where it's still illegal. Items that can be called evidence to a crime. John Doe shot Fred. We search the house, we find a bloody shirt. That's admissible. Items used in committing the crime. We search the house, we find the gun. All those can be found. Now, you can't take everything. It's going to be limited. But those are certainly 4 categories of items that can be seized during a lawful search. Another common way in which people are searches incident to arrest. Now remember, just like a search warrant, you have to have probable cause to arrest someone. If you don't have probable cause to arrest someone, if you're bringing him into custody just because it's a Wednesday and you feel like it, that's inadmissible. So if you are arresting someone with probable cause, what can you do? Well, one of the things is we know that when you arrest someone, they're facing some very severe penalties potentially. So we want to protect the police officers. Police officers can seize any evidence of a firearm that they're carrying, or a weapon, period. Guns, knives, blackjacks. And the other thing that police officers can do when they arrest someone is they can seize any evidence under his direct control, immediate control. This is known as the arm's reach doctrine. So if you arrest an individual in a car, you can search the whole car. If you arrest an individual in his bedroom, you can probably search most of the bedroom. What you can't do is, just because you arrest someone in the bedroom, is go down into the cellar and start opening up cabinets, because that's not under immediate control. You can go get a search warrant for it, but you can't search beyond pretty much the control of the individual you're arresting. One of the most common types of searches, and as a lawyer I saw tons of these, is a consensual search. So you're walking in a public area, a bus station. The police come up to you and they say, hey, can we search your bag? And you don't have anything illegal in it, so you say, sure, go ahead and search. You have consented. Now, the police may not have had probable cause. They couldn't search your bag. But you gave them that probable cause. You gave them the right to search, and they don't need probable cause at that point. If you voluntarily consent, the police do not need reasonable suspicion or probable cause. Now, we can take into consideration things like how old you are. You know, a 5-year-old can't consent to a search. Intelligence, are you in your right mind? Physical condition. Also, coercive. Did the police say, can I search your bag, or do you want me to beat you up? Not going to be a valid search. The length of the questioning, its location. Brief detention very often is not even a search. But if you bring someone downtown and you question them for hours and you search them, you better have probable cause. All right, automobiles are very complex. And some of this can vary from state to state because constitutionally, the federal constitution is the floor of your rights. State constitutions can give you greater rights of privacy. So, for example, California provides greater protection during traffic stops than North Carolina does. We're not going to go into those exact details. But what it comes down to is we don't need a formal search warrant most of the time for most searches of automobiles. If a person is arrested in his car, then we may conduct a search of the car. And if I believe that it's related to the crime, we can stop. Now, it doesn't matter what my motivation for the stop is. I can still search. So if I see someone who runs a stoplight, that's a stop. That's a reason to stop someone and search the car. And I might have wanted to search him for a firearm, or I might have wanted to search him for drugs, and I was just following him, and he blew through a stop sign. He doesn't have the defense to say, well, you searched me, you stopped me for the stop sign. When can a police officer search without a warrant? Well, one of the times is what's called plain view. If a police officer perceives something, he's in the area lawfully, he sees something that he knows is clear evidence of crime or criminality, he may seize it. So a police officer is walking down the street, he sees someone reach into his pocket, take out a joint, and light it. That's in plain view. He can seize it. Now, if that same individual was in his house, took out a joint and lit it, and the police officer, however he knew someone was in the house, he couldn't go in because it's not plain view. Now, we can have issues about technology impacting this. You know, when the technology allows the police officer to extend his vision or extend his senses. Going back to growing marijuana, we talked about just very, very briefly. If you're growing marijuana in the front lawn, that's illegal, and that would be in plain view, and I wouldn't need a special warrant. But if you're growing marijuana in your attic, and I use a heat sensing piece of technology that says, oh, you got a lot of heat in your attic, and I happen to know, well, yeah, grow rooms very frequently located in attics, and that matches the signature. Do I need a warrant to go get it? So you can see where technology can raise real issues about plain view. All right, let's talk a little bit about wiretaps. Now, again, this is going to vary dramatically from state to state. You have some states which are called two-party consent states. You have some states that are one-party consent states. So basically, in many states, including North Carolina, if one party consents to a wiretap, you don't need the consent of the other party. Sometimes neither party is going to consent. Maybe they're engaged in a criminal conspiracy. So the police will want to go get a wiretap warrant. They'll go to a judge and they will say, we have evidence that a crime is or is going to occur, and we would like to place a wiretap on a phone, a cellular phone, or a computer so we can track it. If they can demonstrate probable cause, not just, hey, I think this guy's suspicious, but real probable cause, the judge will usually give them the warrant. They place the tap, and then the tap becomes admissible. Basically, any tracking or searching of cell phones typically requires warrants. And although we can get into problems here. Suppose I stop you, and you've got a cell phone, and I say, hey, can I see what's on your cell phone? Can I see just who you called? Because I suspected you just called a drug dealer. And you say, sure, and you show them your call log. Well, you've consented to the search. Let's suppose I stop you and I want to search your phone, but your phone is password protected. Can I force you to give the password? All of these are significant issues that really are still playing out in the courts. All right, let's talk about one of the most contentious issues, and this is what's called a Terry stop or a stop and frisk. And this dates back to the late 1960s. And I'm going to simplify the case. If you take the constitutional law case, we'll go into the details more exactly, but I'm going to make it simple. Back in the late 1960s, a veteran police officer is walking around and he sees some individuals, we'll make it even simpler, in front of a jewelry store that's about to close, or a bar, it doesn't really matter. And he sees them acting suspiciously and pacing back and forth, and maybe they have long coats on that would be perfect for disguising guns, and maybe they look like they're, rough individuals. Not enough probable cause for arrest. It doesn't, just because people look rough or they're outside of a store or a bar that's getting ready to close, doesn't mean they're getting ready to commit a crime. But as a police officer with experience, and this police officer in particular had a lot of experience, he might know, hey, yeah, this is suspicious. So he went over to investigate. Now, for his own safety, that police officer says, if they do have guns, I want to know about them, and I don't want to be able to pull them out. So I want to put them up against the wall or pat them down. So I'm going to stop them, and I'm going to briefly frisk them for firearms. And when this happened, back in 1968, they found firearms. The individuals who were searched sued said they didn't have probable cause. Went up to the Supreme Court of the United States, and in 1968, the Supreme Court said, given the totality of the circumstances, a brief detention, an investigatory stop, and a brief pat-down is permissible even without probable cause. This is for both. This is really for the safety of the police officer. And the courts have decided now that officers can use the total circumstances to determine if such stop and frisk is permissible. Okay. Like any good tool, sometimes it gets overused. And again, you might want to look at one of those micro lectures about Terry stops and how far it's gotten. But pretty much the police took this as far as they possibly could, to the point really where they were stopping people and conducting more intrusive searches than should have been allowed. Any stop has to be brief, and there has to be some reason that's reasonable for the stop. The police officer can't base this just upon something that's unreasonable, like, that guy's a particular race, or that guy's a particular ethnic group, and that's why I'm going to stop him. That's not a reasonable stop. The frisk has to be a pat down for weapons. It has to be minimal. So if the police officer pats my front pocket and he feels a piece of paper in it, well, the piece of paper is not a weapon. Police officer can't reach in, pull the paper out, read it, and it says on it, go kill Fred, and then arrest me for conspiracy to kill Fred. Improper search. The frisk has to be, you pat someone down, you feel a metallic object in their pocket or in their vest. That could be a gun, that could be a knife. Now you can reach in and get it. By the way, once you find the knife or the gun, unless they have a permit for it, if it's not a concealed carry incident, then now you've got probable cause for arrest. According to the law, a person's race or ethnicity can't be the reason why you stop them. They can be part of the reason, although we have to be careful here. So, for example, if you saw, if you were in a neighborhood that was almost exclusively Vietnamese, Asian American, and you saw someone of another race, a white person, you might say, well, what's he doing here? Maybe well, kids from the suburbs come into, we're going to stereotype here for a second, come into Chinatown to buy heroin. Okay, or opium. I mean, it's not San Francisco in the 1890s, but we'll say it is for a second. That would be enough to alert you. The problem is when that goes too far. When you target people based solely upon their race or ethnicity or national origin, it's not permissible. And we've seen problems with this with things like immigration. So if you had law enforcement officers in Arizona and they looked at someone, they said, that individual looks Hispanic, whatever that means. Can that be the basis for a stop? Well, maybe so. But, think about it at the other end of the border. Suppose you're up in Vermont and think of your typical Canadian. And you see a white person in Vermont. Can you say, well, he's not Hispanic. He is white. Most Canadians are white. That should give me the basis to stop them. You can see how you could take this too far. So we have to be really careful about using race and reasonable suspicion. Okay, stop and frisk clearly can lead to an arrest. And the arrest takes place when really the elements are the police officer decides he wants to arrest, he has the intent, he has the authority, usually means it's in the jurisdiction. He seizes the individual, places him in detention, and the individual is aware of it. So once those four elements are met, we have an arrest. The best way for a police officer to conduct an arrest is when he has a warrant. If a police officer has probable cause and he goes to a judge and he says, here's my evidence, physical evidence, statements of witnesses, observational evidence, that an individual committed a crime. Is this sufficient for me to go arrest him? The judge looks at it, says, yes, it is. Now, here's the nice thing about that from the police officer's perspective. he now has effective cover. So long as that application for the warrant is true, even if it later turns out there's no evidence of crime and someone wants to turn around and sue for illegal arrest, if the warrant's valid, then the police officer is safe civilly. General rule, police officers, when they're going to execute a warrant, have to knock, say we're here to arrest. Under certain what are called exigent circumstances, police officers do not have to announce themselves. And this is going to be if someone is dangerous, if there's a felony in progress, like an ongoing kidnapping, or if there's a danger of the evidence being destroyed. They then wait after they knock, and they can go in. There are no knock warrants, however. If a police officer doesn't have a warrant, can he still make an arrest? Sure he can. One of the ways he can do it is if the offense was committed in his presence. Police officer is at the bank, he sees someone come in to rob the bank. Can he arrest the robber without a warrant? Sure he can. He can also make an arrest if the police officer is sure himself that probable cause exists from a particular suspect. Also, in certain instances like escape or destruction of evidence, the police officer can't take the time to go get the warrant. Again, the police shouldn't take this too far. All right, talking a little bit about Miranda. Miranda comes out of a case, again, we'll cover in constitutional law, called Miranda versus Arizona. And we're moving here from the Fourth Amendment, which is search, to the Fifth Amendment, which is essentially questioning. And the Fifth Amendment of the United States says you can't be forced to be a witness against yourself. A little bit more to it than that, but we'll keep that as our overarching idea. The Fifth Amendment says you can't coerce people into testifying against themselves. You can't use physical force. You can't use mental intimidation. Under Miranda versus Arizona, if you are in the custody of the police, and here's the second part, they're going to interrogate you, then they have to give you warnings what they're about to do and make you aware of your constitutional rights. This is a custodial interrogation. So, what's not required? Well, if they're going to ask you non-testimonial questions like just what's your name? If they haven't focused on you, they're just at a crime scene and they say, did you see who ran the stoplight? If someone comes up and volunteers information. If it's during a stop and frisk where there's no arrest. If it's a traffic stop, there's no Miranda rights. Suspects can waive Miranda. Remember, Miranda quickly is you have the right to remain silent. If you give up the right to remain silent, anything you say can be used against you in a court of law. You have a right to have an attorney present. Can't afford an attorney, will appoint one for them. Then they ask if they understand it. And there's no absolute set form for this. It just has to broadly cover everything. We do have to be careful because one of the things we found is that people will confess to crimes they don't commit. And this can be very difficult for students to understand, but it does occur. In pressure situations, you get people to admit to things because they believe they're going to get out of that situation, even though they didn't do it. So sometimes a police officer, and remember, police officers can lie to suspects. Police officers can say, things will go easier on you if you tell me the truth. And that may be a complete lie. Or the police officer might say, well, we have evidence that you committed this crime. And if you admit it now, it's much better. Well, they might have no evidence whatsoever. Or they might say, we've got fingerprints when they don't. We might have the gun when they don't. One of the ways we get around the idea that an interrogation might be improper is videotaping. Not always done, however. Okay. That was a little bit quick. About a half an hour. Tried to get through it. We're going to continue with Chapter 7 coming up. Hope you enjoyed this one.